Question for today is, can an attorney ethically insert an arbitration provision into their engagement agreement with their client? That's a question that has not been answered before until recently by the Second District Court of Appeal in the Johnson Pope versus Fourier case. And the Second District held the answer is yes. Now, the Second District opinion leaves almost as many questions as it answers it gives, because it was pretty straightforward in its opinion. It said three things. One, there is no prohibition in any constitution. It's not violative of public policy for an attorney to insert an arbitration provision into the fee agreement. Two, there's no Florida cases on the subject saying that you can't do that. And three, any ethical questions, disciplinary questions, can be taken care of in the opinion itself. So where does that leave us? Sounds like perhaps it's a good idea to do that. Well, maybe it is, maybe it isn't. Depends on your particular case. First of all, let's look at the history of arbitration provisions in fee agreements for attorneys. The Florida Bar actually had an opinion on this, or proposed opinion, several years ago in 2002. The Professional Ethics Committee of the Florida Bar proposed opinion 0209, which permitted attorneys to insert arbitration provisions into their fee agreements, meaning arbitration of everything, not just the fee themselves, but also any disciplinary, not disciplinary, but malpractice questions. And the opinion itself had some requirements in there that the attorneys should adhere to. First of all, of course, the agreement had to be in writing. Second of all, the client had to consent. Third, the client had to give informed consent. Fourth, the client had to be advised of the fact that they were waiving their right to a jury trial and had to understand that particular fact. And fifth, the client had the opportunity to have independent counsel take a look at that fee agreement, in particular that arbitration clause. Interestingly, it was not required that independent counsel review and agree and offer an opinion that the agreement was fair and reasonable. So that was all that was required. For some reason, that particular proposed advisory opinion was not accepted by the Board of Governors, and that went away. What came in its place was an arbitration provision for fee disputes, but not for malpractice claims. And that's what led to the Fourier decision. Now, having said that you can do this, and even having a little bit of a roadmap from the proposed advisory opinion, the question becomes, should an attorney do this? Well, consider this. Self-regulatory organizations for years have had arbitration panels composed of typically some industry insiders and some public arbitrators. And the folks who are subject to those arbitrations, the self-regulated professionals, have said for years that the industry arbitrators are tougher on them than the actual public arbitrators or non-industry arbitrators. So consider that for a second. Do you want your case arbitrated by three attorneys who are very aware of the public perception of attorneys and very aware of the fact that if they were to, quote, let an attorney off, that they would be subject to a good deal of criticism, and also very aware of the fact that their profession, their livelihoods even, may be impacted by the fact that other attorneys may have committed malpractice? In other words, would those attorneys be tougher on the attorney before them than a jury might be? Now, it's tough to predict that, of course. It's almost impossible. But you may want to consider whether or not you want to do it, depending on the type of practice that you have. If you have a highly complex practice, let's say drafting securities agreements, public offerings, those types of things, you may want to consider an arbitration provision, just because it may be a little confusing for a jury to try to understand such a provision. If you have more of a straightforward practice and you don't think that it needs to be highly technical, and you'd have no problems whatsoever, of course, explaining your case to a jury, then you may want to avoid the arbitration issue, especially if you think that you practice always with a good deal of professionalism and the highest ethics and the highest competence. So it all comes down to whether the attorney wants to do it and thinks it's best for him or her. But you need to consider whether you are actually making things worse for yourself by including an arbitration provision as opposed to just deciding to go straight to litigation.